Hi, myself Ramakant Pathak. I'm sitting with my partner Shilpi Jain. The current topic is incorporation, formation, and registration of company under the Indian Companies Act. Out of various modes available to do the business, the company is most popularly accepted mode. The video will this video will help the investor and promoter to decide the best type of the company, its character, and level of compliance in India. Companies are registered under the Indian Companies Act and is governed with various rules, regulations issued by the Ministry of Corporate Affairs from time to time also. To decide the right type of the company, the promoters required to consider the various factors. At first, the promoters required to decide whether the proposed company is being incorporated for earning profit or for charitable cause and promoting commerce, arts, science, sports, education, etc. Section 8 companies are the best suitable for doing the charitable business and non-profit activities. A separate video providing complete detail of Section 8 is already uploaded on the YouTube channel.
For earning profit, the promoters may choose private company, public company, one person company, to be known as OPC. To understand this type of companies, it is better to refer definitions first. Section 2, Clause 68 of the Companies Act 2013 define private company, which means a company having a minimum paid up share capital as may be prescribed, and which by its articles restrict the right to transfer its shares, except in case of OPC, limit the number of its members to 200, prohibits any invitation to the public to subscribe for any securities of the company. The name of the private limited company and with words private limited like ABC Technology Private Limited. At the time of formation of private companies, there should be minimum two or more members, minimum two directors on board, and one of whom shall be resident in India. Private companies are incorporated by the family members, friends, and is a closely held company. So law has provided more flexibility in conducting their business operations compared to other type of companies with various exemption of compliances. As per Section 2, Clause 71 of the Companies Act 2013, public company means a company which is not a private company, provided that a private company which is a subsidiary of a public company shall be deemed to be public company for the purpose of this act, even where such subsidiary company continues to be a private company in its articles. The name of the public limited company and with word limited like ABC Technology Limited. At the time of formation of public company, there should be minimum 7 or more members, minimum 3 directors on board, and 1 director shall be resident in India. Public companies have strict legal requirement compared to private limited companies due to their nature of having shareholders from the general public. To protect the interest of investors or public, more transparency and disclosures are required, which in turn increase the compliance burden on the company. One person company means a company which has only one person as a member. The name of the company will be in form of ABC Services OPC Private Limited. At the time of formation of OPC, there should be only one member. For the such member should nominate a person who shall, in the event of the subscriber's death or his incapacity to contract, become the member of the company. OPC is suitable for small business structure. More members or shareholders cannot be added to OPC to raise further capital. Thus, with the expansion and growth of the business, more members cannot be added.
Next stage is, for the promoter is required to decide the capital limitation of liability of the members. Depending upon the nature of business, requirement of fund, the capital of the company may be decided. The authorized share capital, subscribed capital, face value of the share are main factors to be decided initially. Under the Indian Companies Act, companies are further categorized on the basis of their liabilities. Company limited by shares. The company in which liability of a member is limited by the liability clause in the memorandum of association of the company by the fixed amount is termed as company limited by shares. Company limited by guarantee. A company that has liability of its member limited by such amount as the member may respectively undertake by memorandum to contribute to the asset of the company in the event of its being wind up is known as the company limited by guarantee. Normally, company with charitable objects are incorporated under this category. Unlimited company. In this type of the company, the liability of the members of the company is unlimited. The system has provided Spice and Agile Pro as a single window form for incorporation with the company. With this form, this form can be used for incorporation of all type of the companies, allotment of ESIC or EPF, allotment of PAN and TAN, registration under GST and IEC, registration under the Shop and Establishment Act. That means we are not requiring to file separate forms for registration under the different. The next is registered office. The promoter also required to decide the place of the registered office. Although various process of MCA is centralized, but jurisdiction of ROC depends upon the place of the registered office.
The registrar, on the basis of document and information filed, register the company and issue a certificate of incorporation in the prescribed form under the Companies Act 2013. Certificate of incorporation include 11-digit SIN, PAN, TAN of the company. After incorporation, the registrar, on the basis of documents and information filed, register the company and issue a certificate of incorporation. Certificate of incorporation include 11-digit corporate identification number, PAN and TAN of the company. After incorporation, the company required to open a bank account and the subscribers required to pay subscribed capital against the share they subscribed. Then the company required to file a declaration in Form INC 20A with the registrar that every subscriber to the memorandum has paid the subscribed capital. A company shall commence business and is exercise borrowing powers only if the above-mentioned declaration has filed with ROC.
Now we will discuss the practical difficulties and challenges encountered during and after the incorporation. At the time of incorporation of the company, Form Agile Pro require the rent agreement of the company of the place registered of the place of registered office if the premises is not owned or by the promoter or director. Practically, execution of rent agreement before the incorporation is a practical problem, because sometimes owner refuse to execute the rent agreement with the company which does not exist as of that signing of the rent agreement, and after the incorporation the company again required to execute a separate rent agreement. This double the cost of the stamp duty and resistance from the promoter and the landlord of the premises. Form Agile Pro required to compulsorily fill the detail of the registration of the company under the ESI and EPF Act. This creates the practical problem. All the companies are not required to get itself registered under the ESI or EPF at initial stage, as they may have no employee that time. If the company is initially registered with the correspondence address and has not finalized the registered office, then selection of the jurisdiction of ESI and EPF is not practically possible. Although there is a provision to make the status dormant on ESI and EPF, but the website of the department does not support for it. So these are certain practical problems which we try to communicate.
Right. I hope you have liked the video. For getting more such kind of videos, do subscribe to our channel and press the bell icon for getting new updates. For connecting with us, you can visit our website indiglobe.co.in. Thank
Thank
you.
you.